Good afternoon and welcome into the first of two Judicial Retention Committee hearings before our judges. And I would remind committee members there are other items that we want to make sure that we're putting on our calendar. There's a public hearing next Wednesday, the 11th at 7 p.m. in room 267 of the Pavilion building. Oh, good. Which we will all want to attend. And then we have the second of the interviews the day after that on Thursday, the 17th of February. And that will be in this room again, beginning at 4:30. So we're happy that the House has apparently released our two other members. And I'll let you just take a deep breath, Representative Arsenault.
Yes, carry on.
Good. So I'd like us to go around the room and introduce ourselves and tell folks where we're from, and then I'll turn it over to the chair. If I can also get all three judges to get sworn in at the same time, it'll save time. So let's start with this side.
Okay. Hi, everyone. I'm Senator Ruth Hardy from the Addison District.
Hi, I'm Representative Alicia Millay from Pittsburgh.
Senator Terry Williams from Rutland District.
Martine LaRocque-Ulick from Burlington, Chittenden Central District.
Brian Collmore, also representing the Rutland District.
Hi, Representative Angela Arsenault from Williston.
Representative Oliver from Sheldon and Swanton.
Hi, folks. Connor Casey from Montpelier.
So if I could ask all three judges to stand and be sworn in. Do you solemnly swear or affirm, subject to the pains and penalties of perjury, that your testimony tonight shall be the truth, the whole truth, and nothing but the truth? Okay, great. Representative Arsenault, I believe you may now drive the bus.
Okay. Thank you all for getting started.
Sure.
I was up there watching the clock. Things were happening. I was like, oh, we're not going to get down here by 4:30. So appreciate that. So we don't have a specific order. If there's anyone who would like to go first or needs to for any reason. No. Okay, then why don't we start with the Honorable David Barra?
Good afternoon.
Good afternoon. Hey, and welcome. So the way this tends to work, and for any who might not be familiar, is that we will invite you to start us off, share your thoughts, statements, whatever you would like to share. And then, of course, we have received this binder. We've had a few, at least a week to go over it. So we've read through things, and we'll give an opportunity to each committee member to ask a question or share a thought. And that pretty much wraps up. That's sort of the flow for each judge. So if any questions about the process? Great. Any questions from committee members or thoughts or anything I'm missing?
No.
All right, great. So please get us started. The floor is yours.
Okay, well, let's see what I can do. So good evening, everyone. Thank you for the opportunity to be heard tonight. I appreciate you being able to come before you and speak. It's been 5 years since my last COVID delayed retention. Some of you may recall we started the process and then had to postpone it for a year. I'm constantly amazed at how quickly time has passed. And yet how much things do seem to be the same in many ways. The work that I do is challenging, important, and also very humbling. I believe I have gotten more efficient with the use of my time, better with the technology that we've adopted and continue to adopt and change. And I'm more comfortable in the role that I've had now for nearly 8 years. Retention is an opportunity to reflect on what has preceded today and what I can do to get better. Since last time here, I completed a family rotation in Rutland, and then I sat in Grand Isle, which is all dockets. And at the same time, I was in Franklin Civil and Domestic for a year. Then I went back to Rutland Family. And then after that, I've been every year, at least part of the time in Bennington Civil. But I've also spent a significant amount of time during those times in Wyndham Civil and in Addison Civil. During my time in Grand Isle and Franklin, I also had a significant amount of time spent up in Orleans and in Lemoore. Most of what I heard during that time was civil, but there was also a heavy dose of other things like family, domestic, things like relief from abuse, things like criminal weight of the evidence and things like that. Just last month, I was very excited that I was assigned to hear 2 oral arguments with the Vermont Supreme Court. That experience was new and very interesting to me, and gave me some insight into really how that part of the process works. I've got decisions from the Supreme Court, but having to be able to participate was pretty exciting for me. So as you can tell, most of my recent assignments have been as a civil judge, and those things that most often I preside over include rent escrow hearings, other landlord-tenant issues, foreclosures, credit card collections, wage garnishments, trustee process, tort cases, wrongful discharges, any number of, any variety of small claims cases, stalkings, both an emergency dealing with paperwork to get emergency orders out the door, or scheduled hearings to hear the cases, motions hearings, bench trials, and jury trials. We've been able significantly now to increase the number of civil jury trials that we've been able to have. There was a time right around COVID, right after COVID, where we just couldn't have any jury trials in the civil division, but now we have been, and I've been happy to be able to preside over several this year, both in Bennington and in Addison. There's just a real wide variety of cases and kinds of cases that I hear. No week is like the week before or the week after. I get a fairly healthy amount of tasks put into my queues from the various judicial assistants that are working in both of the courts that I'm sitting in, and then I do what I can to keep at the queues so that the tasks don't become insurmountable or take too long to get to. I try very hard to turn the tasks that are given to me around quickly so that those who sent them to me can complete their work, and those affected by the decisions don't have to wait unnecessarily long time. And also, emergencies do come up with some regularity, so that it's helpful to have to keep on your docket, so that if you have to move flexibly from one to another thing and then return it, it's helpful. So it's been my routine practice to try to do that. During this time and including this week, I've routinely also heard relief from abuse petitions that are in the family division, both emergencies and scheduled hearings. And in Bennington, I work closely with Judge Valenti at least once a month when we pick juries in the criminal unit, so that I'll be helping by getting the juries picked while Judge Valenti is working on in another courtroom and getting other matters moved along. So it seems to work well for us down there in Bennington. I've also participated in weight of the evidence hearings and other criminal motions this past year. After hours calls are another part of the job that we have to deal with, and that includes being called for conditions of release, search warrants, mental health orders, juvenile matters, and more recently added to the after hours has been civil sexual assault complaints. And I did have my first call the other night about such a complaint, and we got it processed and had a hearing for it. My style and my goal is to spend most of my time learning, training, listening, and reading. At least I'm doing one of those things now. I'm reading. I'm not listening very much at this point, but I do try. When I do have a hearing and I'm doing little talking and others are doing a lot of talking, I feel like I'm succeeding. I do learn best from watching others, also from doing things. And I do try to learn something new every day. My goal is to improve my skills, increase my understanding, stay current with the latest changes in the law, and try to find out from others with experience and expertise, techniques of becoming a better judge. I do at the end of each day try to take time to assess what happened that day, consider what went well, what could be improved, and make notes where applicable in our upcoming cases. In that regard, our technology has helped us in that there's one of our systems we use is Judicial, which allows me to, for every case that has a hearing scheduled, I can go in and put notes and have easy access to documents and pleadings that are associated with that file. And I can cut and paste and make sure that I have the notes that I need right at hand when the hearing starts. I try to spend the time necessary reviewing every file before every hearing. Multiple times is the usual. I'll start on a Friday, looking ahead for the week, doing initial notes about each, and then as the day get closer, and depending on what the hearing is about, I'll go back and flesh out the notes. I try to anticipate the potential issues and develop strategies to how to deal with those potential issues. I feel that being prepared projects the sort of knowledgeable and professional persona that the participants in the hearings deserve. I try to appear serious, attentive, but also relaxed and confident to those who appear before me. My goal has always been to treat everyone fairly and with respect. I explain my decisions so the parties will know why I am deciding the way I decide. Sometimes I can't do a decision orally because there isn't enough time. And if that's the case, then I will try my best to get a written decision done as soon as possible after the evidence has closed. And I explain to the parties that that's what the process is going to be. Parties do deserve prompt attention to your cases. I believe I've gotten better at this work over time. I hope to continue to improve going forward. I strive in my daily work and in my contacts with others, co-workers and parties that appear and lawyers that appear in front of me, to be approachable, available, and accountable to all of them. Every day I look forward to the issues that await. I hope that I can project this enthusiasm for the job to those that I work with. At the same time, I'm aware that many who appear in court are not happy to be there. They are anxious, upset, confused, and sometimes angry. I do what I can to help keep the atmosphere safe and conducive to getting the needed work done. I appreciate the opportunity that retention provides to get meaningful feedback from attorneys and staff. I take all of this feedback seriously and try to learn from it what others feel is working and what needs to improve. the critical comments made in the questionnaires have given me things to think about and to adjust accordingly. I would not want anyone to leave the courtroom thinking that I favor one side over the other. By and large, I was encouraged by the comments in the questionnaires. I still have much to learn and am motivated to try to get better. I try to treat everyone fairly and with respect. Thank you all for listening.
And thank you. I think for questions, maybe we'll start over here and just go around the table. Start with you, Representative Casey.
Yeah, sure. Thanks so much, Judge. I really appreciated your emphasis on, making sure the accused get justice in a timely manner. And, I serve on the corrections committee and the system's just swelling with detainees, right? So I'm wondering what you think are sort of structural bottlenecks that affect case resolution, and what do you think we could do to help out on that?
The bottlenecks. Well, I'll tell you that your focus, at least in the beginning of the question, was focused more on the criminal side of things. Most of my decisions, most of the things that I'm writing relate to civil matters.
Mm-hmm.
So, and we have our own bottlenecks and our own backlog. So I'll address what I think we could do or can be done to help resolve bottlenecks in civil matters. The principal impediment to getting a lot of cases resolved is there isn't enough time for everything to be heard. And when there is enough time, sometimes the people aren't available because they're the same people. I think that does carry over into the criminal side as well, since you might have another space to have a trial and a second trial, but at the same time as you have. But if it's the same lawyers involved in both trials, you can't do it. So those sorts of structural impediments I'm not sure how to fix those. But with respect to how to get backlog and get more hearings, I'm not sure there's a solution that doesn't involve some more resources to get another decision maker working on the same problem.
Sure. Thanks very much.
Sure.
Hello.
Yes. All right.
I'm gonna make an observation first, and then I got a question.
Okay.
And my observation is pretty important to me, and it looks good, is that the staff, the court staff, non-attorney group of people really seem to respect you and have like to have you around. And I think that's pretty important, and it shows if that's not going well, other things probably aren't. And I appreciate that. The other thing I have a question about, Senator Hardy and myself both had an interest in the civil sexual assault bills. And I would like to know what your experience was like going through that process, and if you thought it was helpful or not.
Okay, well, your initial comment was something that when I looked through the questionnaires, it really warmed my heart. I do have a good relationship with the people that I work with, and I thought I did, and they confirmed it. And I do enjoy people that are in the judicial. They're just great people to work with. So they make it easy to work with. With respect to the civil sexual assault issue, I've only had one after hours complaint filed. And I don't think it's going to be very representative of all of the ones that I would expect. This involved an after hours call where a young woman called about incidents that had happened many years before. And it was, so there wasn't an urgency or a recent event that had occurred that triggered this. It was somewhat confusing as to why the issue was brought up. But and the the after-hours worker who fielded the call was a little confused about whether or not we could proceed. So we ended up working together. I gave her some advice and asked her to get some more information. The temporary order was granted and we scheduled a hearing. And I was scheduled to preside over the hearing, and I was looking ahead to that and ready to go. But then the plaintiff didn't appear. And I don't know anything more about that. So, because we don't so I'm hopeful that that won't be representative of things going forward. I do think there is a need for that the after hours civil sexual assault complaint process does serve a need that may fall in between things that were handled through law enforcement or other means. But this specific case, I can't really speak to it.
Well, thank you very much.
Thank you. Yes.
So I want to first say that certainly, as Representative Oliver pointed out, when we look at the survey results, overwhelmingly positive. And so the focus on the negative is not to say that imply in any way that was the bulk of the feedback. But in fact, I did note that I thought this was a really nice bit of feedback from an attorney who said his opinions are well reasoned regardless of whether it's a win for my client. I think that seems pretty ideal. My focus was drawn to feedback from an attorney about juvenile court. And I know that's not probably, where you spend the majority of your time, but I wondered, this person shared thoughts, opinions, he had a distaste and disdain for the low income, lower class people who wound up there. I just wondered if, always courteous to attorneys, but uncomfortable with the unwashed masses. The language certainly stood out to me. It's, and I just wondered if you could share thoughts on maybe, if not the comment specifically, your experience dealing with juveniles in court and how or if you approach juveniles differently than adults. It's an area of interest for me, serving on the Judiciary Committee and wondering how we can improve our juvenile proceedings. So I'm just curious to hear your feedback.
First off, I am troubled by that comment. I'm sorry to have left that impression. But I don't try to appear disdainful towards anyone who appears in front of me. The juvenile docket is a difficult one, and while I was in Rutland for 2 years, we had a steady stream of very difficult cases, also involving violation of parental rights and other issues that involve difficult things to think about when they involve children, violence and other types of abuse. I do find those kinds of cases difficult. They stay with me. They are ones that I really work hard, extra hard, to be sure that I'm getting the decisions right. I do try to hear from everybody in the juvenile courtroom, as I'm sure you know, that everybody is spread out, and I'll go down from one side to the other and back to be sure that everybody has had their opportunity to express themselves. Sometimes it's the person themselves, sometimes it's only the lawyers that talk, depends on the hearing or the thing that's they're discussing. But this idea that I'm some elitist, some rich person that disdains poor people. I don't think that's my background. I don't know how I could have given that impression. I'm sorry I did. And I will work harder to not give that impression in the future.
Thank you.
So, you gave testimony tonight and I read the letter, which was the retainment letter, and was very heartened to hear, as you say here, the variety of issues, staff, lawyers, and parties that I've worked with has been a challenge, but one that inspires me to work harder. The learning curve has been steep, but I believe I am making progress. And you intimated that in your remarks earlier, and I think that's critical. I'll also say just, it seems like it's human nature for the attorneys who fill these out to have a little different view than the staff might. I think there are some, it's just human nature. If you win a case, you lose a case. I do some officiating on the side, so I'm used to kind of being on both sides. But with that in mind, you did do extremely well, as my House colleagues have pointed out, with the staff. It was 100%. And even with the attorneys, it was 93%, I think. So I'm just curious how you reacted to, and this is also strange, the same sort of comment was raised the same day by, I assume, two different people, but I don't know, maybe it was the same person and wrote twice. I'm very concerned about Judge Barrett's retention. I and my colleagues have had multiple experiences where Judge Barrett has ruled in ways that directly conflict with statutes and rules of procedure with no explanation or apparent understanding. And the second one says, I have serious concerns about Judge Barrett's retention. Personal experience and reports from respected colleagues have shown multiple situations where the judge has failed to follow substantive law and rules of procedure. And to me, that speaks, at least from my view, more directly than someone's impression of how you feel about somebody might be. We can all look at each other and assume that if we're getting a smile back, it's probably okay, and maybe not. Anyway, the rules of procedure and the actual court situation were something I just wanted to touch on. So, not sure how you react.
I think these two comments specifically relate to escrow hearings. That's the only thing I could come up with as to where this came from. And they relate to a disagreement as to the provisions of 12 VSA 4853A and the application of ERCP 7. So what does all that mean? Well, it means that if, in an eviction action for non-payment of rent, the landlord can request pursuant to the statute that rent be paid into court while the matter is pending. And the statute requires that the landlord file a motion, a written motion, supported with an affidavit of on personal knowledge, and give at least 14 days notice of a hearing. Sort of all that along with the complaint and other things related to the filing of a eviction action. And then there's a hearing. The hearing under the statute is pretty clear to determine on the motion and the affidavit what should be done, and also when the timing of payments and the amount of payments that might be required by granting it. There has been some opposition, but none in motion form or in writing or expressed to me at a bench bar that this isn't the way they want it to be done. But it does seem to me that this issue as a whole is good grounds for an upcoming bench bar, so we can have a discussion about this. But so my practice has been to schedule those hearings, and we've had over the years, ever since I was in private practice doing these sorts of things, there were scheduled multiple hearings of the same kind, all in the same morning. So there might be 6 or 8 of them scheduled for the morning. And what I think the comment is relating to is if someone does not ask for an evidentiary hearing or has not filed their opposition in writing as the statute requires and the opportunity to present evidence as the rule requires, then I will say, we're not going to hear evidence today. We don't have enough time. This is scheduled for 9 o'clock. I have another one at 9:30. There's not enough time to hear, but we can schedule a motion, an evidentiary hearing on a motion if you file asking for that. So I think that's where those comments are coming from. I'm somewhat troubled that it seems to, the comments go on beyond that this is something that I routinely ignore rules and don't know the substantive law of things that I'm ruling on. I'm sorry they feel that way. You could look at my the decisions that I do make seem to be generally affirmed when I do work on cases that get appealed to the Supreme Court. So I do think that I do need to do some work, in particular on that topic with the attorneys that practice in that area let's have a discussion about it.
Thanks, John.
Thank you.
I was going to bring up the comment by an attorney that Representative Arsenault brought up with the juvenile court and the comments that were made by that attorney. You seem to suggest that it was an aberration and that this isn't something that happens typically, but I also just noticed that in your opening statements, you really highlighted the fact that you like to learn and you really lean into making yourself a better judge. So I'm wondering, in light of this particular comment, might there be something that you focus on in terms of improvement, or is there anything that you might try to focus on to, support the marginalized and the folks who are in juvenile court who might need a little extra care, or just maybe living in poverty, or there's all kinds of circumstances there, but I was wondering if you could speak to possible improvements that you might be able to make.
Yeah. I'm up, kids. Speaking of officiating, I officiated sports for and I've always maintained a good relationship with the young people who I worked with, including referees, young people, referees that I trained, mentored, and had the pleasure of working with them. I believe that if I do have any further juvenile matters that I am presiding over, it is something that I will be very aware of. That there are some people who perceive me, and I will try what I do to overcome that. Young people are terrific, and it is very troubling when they are the subject of cases like this, because they're even though they may be acting out or up in front or have done something, there's a difference between a child and an adult doing similar behaviors. And I'm aware of that, and I try to project that and try to make the courtroom a safe place for juveniles. I must say, I don't and have not had a lot of experience with juvenile matters, so that was another thing that troubled me. I can't recall the last time I was in a case that involved direct contact with the juvenile, in a delinquency or something that we had to talk directly, but, should that arise in future, yes, this has been brought to the front burner, so I'll do what I can to get the training I need. I rely on others who've more experience in the area, talk to them about this, as I've done in similar types of things.
Thank you. I think sometimes entering into a situation just with the awareness is helpful, so I appreciate you mentioning that. Thank you.
Good evening, Your Honor. And I want to thank you for your service to the state and our communities. And I keyed in on the same things that a couple of my colleagues have keyed in on towards the end. Your staff and your colleagues think the world of you, from what I read. The attorneys, there was 15 comments that say you're a great guy. There were 3 that said they had never served in front of you. So, and there were actually 2 that looked like they sat down the same day and maybe shared the same comments. I did see one here that I'd like to ask you about. I'm gonna have to use my cheater because the print's too small. Says Judge Barrett usually finds plaintiff's hearsay testimony more credible than defendant's testimony based on personal knowledge. He protects pro se plaintiffs more than pro se defendants. His rulings are strictly legal arguments have improved. Can you comment on that?
I like the last sentence. The first line, hearsay testimony, I don't really know what that means. But I don't believe that as a class of things, believe plaintiffs more than defendants. And but it seems similar to the argument being made on those other 2 comments that there seems to be this perception that when I rule in favor of a plaintiff against a defendant, that I am doing so because of a bias towards them, when I am trying very hard to rule based on what the facts are, and then what the law requires I do based on those facts. There's very little discretion involved in many of the decisions that I made. If the facts are this way, the result is that way. It has to be. You either win and the evidence is you win this X number of dollars, or you lose and you don't get X number of dollars. That's the usual decision that I'm making, and it's based on what the law says. So I don't, so the focus that plaintiffs always offer hearsay testimony and defendants always offer testimony based on personal knowledge. I don't understand that comment, but because lots of people present evidence of based on their personal knowledge and also insert some hearsay, and some hearsay is admissible and some hearsay is not, and try to make the rulings about what's admissible and what isn't. In small claims matters, which I assume an attorney wouldn't have been involved in, but we do have attorneys involved in small claims. The rules allow for hearsay to be admitted as long as it's the kind of thing that the court finds a person would reasonably rely upon. So that if this is related to small claims things, maybe that's what the experience was. But I also try in those cases to make it clear that the reason I'm relying on this hearsay testimony is because it's this kind of hearsay, and I find it reliable for these reasons. And if I haven't made myself clear enough in situations like that, I will try in future to put in either oral decisions that I make in small claims or in written decisions that if there's hearsay testimony that I've admitted, this is why I'm doing it.
Thanks very much.
Good evening. Well, all the questions that I've had have already been asked and answered. So I guess I would just reiterate that while there are few, negative comments from attorneys who have appeared before you, the people that work with you every day, the court staff, unanimously agree, and have great things to say about you. So that's very telling.
Thank you.
Thank you. I guess I'm the last one. It's nice to see you, Judge Farah. I actually have a few questions. Sorry, guys. A couple things that haven't come up, and then one question I want to dig into on one of the cases you submitted as a writing sample.
Okay.
Two things in your record that seem to be part of who you are, especially as a judge, are one that you prefer remote court and that you've been using remote court a lot. And it seems like most of the comments about it are positive, that you use it well and you are, it is appropriate and it helps you be more efficient. But there are a couple, I'm wondering if that might be contributing to some of the other comments. If you're remote, it's hard to be more personable. So just wanted to hear your thought. I can ask you all three of my questions, or if you want to take them one at a time, which is your preference.
Probably be easier to remember the questions.
One at a time. Okay, so that remote court.
I don't use remote for everything. That's for sure. It isn't appropriate for everything. What it has been particularly effective in hearings where, for example, stalking hearings and racial abuse hearings, where having the two parties in the same room causes its own issues. So having them remote in those situations has been very helpful. Also, for routine sort of status conferences and pretrial conferences or discovery conferences, where all we're really talking about, and it's usually just lawyers, you're just talking about scheduling issues and trying to resolve minor things and making sure things are on track. Those things, rather than requiring a lawyer to drive a couple hours one way or the other and charge his client, lots of money, having the ability to do it seems to work well for everybody. So those types of hearings I do routinely remotely. This year, as I was saying about jury trials, we've had several, and one involved down in Bennington, and certainly I didn't do that right.
Yeah.
We were in court every day. And in Middlebury, we did the same thing. That was a 10-day trial every day. I do some bench trials in person, especially when it's either an attorney that requests it and explains why, or a litigant that does the same, or sometimes it's a self-represented litigant that I think would be more comfortable in person with me in person. So I may do the pretrial or the status conferences with those people remotely, but have the trial in court. A lot of times we use hybrid, meaning if the person wants to appear, they can. If they don't want to appear, they can appear remotely. And most of the time with those hybrids, I'm in the courtroom. Sometimes I'm not. It depends on what it's for and what I expect, how difficult it might be to present evidence. So I don't, if the impression is that I always do everything remotely and don't like to work on that, I think that's a too extreme. I do what I think is more efficient and, appropriate for the thing that we're doing. Remotely, but I do get to, court quite a bit and, do things in the courtroom. Not only for the cases that we're hearing, but physically being in the building helps with the relationships with staff. So I do
Yeah.
try, I do try to go there and spend some time in between hearings, speaking with staff, going down where they all are and making sure that I'm talking to not just the judicial assistant that was working with me in that particular hearing, but others who have been sending me tasks about other things and just find out what else is going on with me. I need my input in, or what else is going on, how am I doing? Are there things that we're not getting done as quickly as we should? And I find that that is very helpful to spend that time in the courthouse, spending time with staff, as well as the time physically in the courtroom with parties. And so I hear the comments that some people think we're using remote too much. I will try to fine tune that to see if there are some changes I can make to get into the buildings more frequently.
No, I mean, I appreciate that, and it does sound like you're trying to figure out what are the most appropriate and following what is the most appropriate for remote and in person, and the staff clearly has appreciated you and the time in person as well. And it does sound like actually you could help other judges use remote better, because remote meetings can be really hard and hybrid meetings are the worst. So if you've successfully done that, then that's pretty impressive. Okay, similarly, one of the things you didn't mention, but is clearly a big part of your record, I was like incredibly impressed. Look at these lists of all of these continuing education. You seem to be a continuing education junkie kind of, which I mean that in an affectionate way. And I'm wondering, you said that you learn best by watching others. And I'm wondering if you might also, is that part of why you take so many continuing education and participate as both a teacher and a learner?
Yes.
It was a softball for you. But.
So a lot of the opportunities to learn come from our regularly scheduled meetings as judges. We set up a lot of things, and I take those seriously, take notes, listen, and all that. I do try to attend all of the courses that we are offered. I've been asked to do a couple of courses over the years. I just did one late last year, and it was surprisingly enough on rent escrow hearings and other things. But
and you just got your master's degree recently.
No, I have not gotten a master's. No.
Oh, I'm mixing you up with another Dutch.
Okay.
I'm sorry.
It's okay. So,
We have a lot of reading to do, as I'm sure you're aware.
so I do spend a lot of time doing and trying to improve my skills by taking all of the courses available to me. And the things learning by doing, I had really the good fortune to be with Justice Cohen, when I was first appointed down in Bennington, and he took me out on the bench several times with him to watch him do stuff. And then it turned into, we were together, but he was watching me do stuff. And we would talk to each other before and after, and it really, I think, helped me learn better. It's sort of method that I used as a referee. It also it started off in, especially at the higher levels, as watching someone else. Every match then you got assigned, you would be assessed and you would talk with somebody afterwards. And I try to continue to do that in my work is prepare for it, do the work, and then talk with somebody who's either seen it or experienced something similar, and we can share how to get better.
Yeah, that's great. You and Senator Collmore should watch each other regularly.
Glad to.
I have one last question, and this is on the case that, you submitted, it was Savetti v. Turner. It's the, qualified immunity case.
Yep.
And this is relevant to a bill that I've worked on this year and last year, the SALT bill.
Mhm.
Yeah, which we just passed again in finance, but there was a question about a municipal employee qualified immunity, and you were making a distinction in here that I thought was really interesting, and I want to make sure I understand it. That something that is routine versus discretionary that a municipal employee would do. And I think that, and I want to make sure I understand this, that if it's routine, then they do not have qualified immunity, but if it's discretionary, they do. Is that the distinction, or am I misunderstanding?
Having practiced in municipal law for 40 years or so before, the issue, yes, you're on the right track.
Okay.
And until the Supreme Court tells you you're on the wrong track.
Awesome.
And that's, so I think in this particular case, involving the road commissioner up in Iowa lot, the question was whether or not to widen the road.
Yeah, it was so funny.
And the issue was whether or not there was qualified immunity for the road commissioner deciding, or for the town to decide whether or not to. And it seemed that that was a discretionary function that fell completely within the qualified immunity that has been carved out by previous cases, but before they affirmed on that ground. And so my understanding of that distinction, what protects, is what you've expressed generally. Yes.
Yeah.
That's why they did it, and that's what I think what I believe as well. So,
Okay, and if you're an employee of a town, you may have qualified immunity, but the town itself, the municipality, does not.
right, for certain things, the town may not. And
Okay.
the employee may, there is another statute which is slightly different than qualified immunity, but that would require you to sue the town instead of the person if you have a claim.
Yeah.
By, say, an action in town side. And those are the sorts of things that routinely happen where they may sue the wrong person. And then we have to sort out who the right person is.
Yeah, and this was one of those cases you sort of went through, this is not the right, this isn't right, but this one is. Yeah, it was really interesting and really relevant. I'm gonna share it with our legislative council attorney, although he probably already knows the case, but thank you.
Thank you. So, anything else? All right, well, I appreciate it.
Thanks, Sean.
Thank
you.
Thank you for your time, your attention. And I think, you guys can choose.
I'm gonna pass out cookies, anyone cookies?
He decided alphabetical.
All right,
Okay, does that work?
sure.
Pass on, yeah.
I think it works especially in the order that we've.
Usually goes last.
Right. This is, you have to take advantage of having a W. Would you like a cookie before you start?
Well, would I pick one or will I eat one? Yes, I would, but I'm not going to eat one.
Okay.
But I appreciate that. So Chairperson Arsenal, there's the committee. Thank you for having us. Thank you for giving me the opportunity to speak with all of you about my request to continuing serving Vermonters as a Superior Court judge. So since we were last here, some of us, I have been assigned in Bennington Criminal Division. Then I did Bennington Civil Division for 3 years. During that 3 years, in addition to being assigned in Bennington Civil, I did not have the rotation Judge Barra has, where right now we're at Civil and then Civil in Addison. I was Civil in Bennington, and then I went to Addison and did whatever they needed, which was primarily every Wednesday I would do the RFA docket in the morning. Then they would put some things on between 11 and noon, hoping that we finished the RFA docket by 11. And then I would do whatever they needed in the afternoon. Might be juvenile, might be criminal, might be family, might be one of each. That was sort of that 3 years at Bennington and Addison. Then, and toward the end of that, in April of 23, I was assigned, I got a call from Judge Zone assigning me to go to Rutland the next Tuesday morning. Next Tuesday morning, I meet with then Judge Waples, soon to be Justice Waples, who had been appointed to the Supreme Court because she was running Rutland Treatment Court docket. And so I started in about April of 23, handling that Rutland Treatment Court docket, which was every other week on a Tuesday. After 6 months as the Rutland Family Court judge and the Rutland Treatment Court judge, in family you do juvenile, we had 2 new judges appointed from Bennington. We had Judges Burke and Judges McManus appointed. And when they got appointed, I got a call from Judge Zone who said, I know we just put you at home in Rutland, but I would like you to move to a float judge position, bless you. So you would handle whatever they needed in Rutland, and you would go to Addison and continue to do the RFA docket up there like you were doing and whatever they needed. And if they needed help in Bennington, you can help down there, but Bennington was fairly self-sufficient. So except for conflicts, et cetera. And I said, fine, I'll do that. And so I did that. I finished that rotation last September. And when that rotation finished, Judge Zone asked me if I'd go back to Bennington Criminal, where I was during COVID. So that's sort of been what I have been doing since I was last here with all of you. In thinking about this process, I was thinking about the fact that Vermont judges have 2 core responsibilities that I think about to the folks that we serve. First, we're responsible for upholding the law, the federal constitution, the Vermont Constitution, the statutes that come out of this building, and the precedent of our Vermont Supreme Court. And second, we're really responsible for providing procedural fairness to the folks that appear in front of us. We're responsible to listening carefully to what they want to tell us. We are responsible for issuing reasoned decisions that are based on our laws. And it's with those 2 primary responsibilities in mind that I think about the fact that judges in our service are really responsible for an awful lot with regard to trust in this state. And so I believe Vermonters are entitled to high quality justice. And for me, that means a lot of things, but one of the things that is crucial to that is continual improvement of the quality of our judging. The first way I do that is through self-reflection. As you can imagine, given what I just told you about my commute for the last 10+ years, I have a great opportunity at the end of most days to do that reflection, and I do try to think about the cases that appeared in front of me, the people that appeared in front of me, what I could have done better, where, I shouldn't have used that word, I should have used this word. said that, I shouldn't have approached it that way, I should have done this. Maybe I could have prepared even more than I thought I had prepared. Because those things happen. And so I do try to do self-reflection and correct myself that way. I also try to think about, well, I did that okay. Maybe I should see if there's a way for us to do that in another way. If I can take what I did in the juvenile court and apply it in a family court, or something I did in the juvenile court and criminal court, whatever. So I do that. Self-reflection is very important to me. Second, we get improvement from feedback in an informal way. Judge Zone gives us informal feedback. My colleagues, both of the colleagues here and the colleagues that are not here with me today, give me informal feedback. And some of it's good, and I try and take that feedback and use it in other ways. And some of it is, I wouldn't have done it that way. And I don't disregard that ever. I try to think about it, and then I try to decide how I can use that feedback in a positive way. And then there's the more formal approach to high quality judging and making us all better judges. And that's what we're going through right now. And I want to emphasize that I think that the formal evaluation and feedback that the retention process gives us is very important. And so with that in mind, I'm deeply appreciative of the positive comments that I received in my retention surveys. But I want you to know that those are not merely a reflection of me. Those are a reflection of several things. First, they are a reflection of the fact that I have been very fortunate to have good education. Not only growing up here in Vermont, which set a good base for me, and I really appreciate that, but then my continuing schooling. I did get my graduate degree.
I figured out, yeah, so now you know.
Of Nevada, I got my master's degree there. And I've had courses that I've taken from the National Judicial College. But in addition to that, and more importantly than that, we don't do this job alone. It may look like it because we're the people who wear the black robes, but we don't. I have been very fortunate to have incredible staffs and judicial assistants and comms that have worked with me in Bennington, in Addison, and in Rutland. They are the front line for the judiciary. They are the base that people see when they come to the counter and are upset about something. Sometimes about something I may have written. Those are the people who are out front. Those are the people who do the scheduling. Those are really people at the heart of the judiciary. And so I appreciate all of those people very much and what they have done for me. I also appreciate my colleagues. All of you, I can tell you this from my own personal experience, all of your Superior Court judges are fantastic at answering questions. We're general jurisdiction judges. We can't know every answer to everything. It's impossible to just know it off the top of your head. So there are times that you may need an answer pretty quickly, and one way you can get that is by reaching out. And our colleagues are fantastic, and so I appreciate every one of them. Our assistant judges in the state of Vermont, everybody doesn't have them. We do, and they are wonderful. They sit on some of the most highly emotional cases that we have in this state. They sit regularly in the RFA dockets that I'm on. I've done RFAs in Rutland, Bennington, and Addison, a lot in Addison, and a fair amount in Rutland, and some down in Bennington. We're so lucky to have our assistant judges that help us, and I've been so lucky to have them help me. And then there are our attorneys who by and large in this state understand that zealous does not equal uncivil. There's a big difference there. And when you have attorneys that realize that you can disagree, but you cannot be disagreeable, which is sort of the one rule. Sometimes judges have lots of rules. I've only had one in almost 11 years I've been on the bench, and that's it. Because I try and treat everyone, whether it's attorneys, side judges, staff, the way I would like to be treated. And I think that that has not only served me well, but I'm so grateful to, the other group I do want to mention is for that little over 2 years I spent in treatment court. The Rutland County Treatment Court went from about 8 participants to, I am not sure what the current number is, but the last time I chatted with Judge Griffin, he said they were almost at capacity. And that's because of that entire treatment court team. This is because of the prosecutor, the defender, the multiple members of the Department of Corrections from probation who served on that committee, our coordinator down there, and our provider, the Community Care Network in Rutland, has been fantastic. And I cannot forget our local police department, who I know Senator Collmore actually has had them on one of his shows to talk about what they have done. And so I mention all of that because I'm very grateful to all of those folks, and my experiences and everything that they have done has contributed to my growth and will continue to contribute. But when you look at those positive comments, that's the village. It's not the one person, and I want you to know that. Now, while there were those positive comments, there are things for me to improve, and I recognize that. And I will tell you, I will work every day to improve on those things. There were 2 that I would love to talk to you about for a minute, just because they stood out with me. One was, there was one comment from one attorney who said I rushed them through a hearing. And that is never my intent. And I think if you look at the bulk of the comments, I would hope that's an outlier, not something that I do on a regular basis, not a habit. When I have pro se litigants with me, especially in that RFA docket, last question I always ask them is there anything else you want to tell me? Which can open Pandora's box, but in the almost 11 years I've been on the bench, more often than not, that is very helpful to ask that question. And it also makes sure that they've been heard. And so I don't know that one person who felt really rushed what it was. We do, as judges, have hard stops at noon. And you have to have your staff out of the building by 4:30 is what we're told. So for me, I have a hard stop at noon that I do my best to not go over. And I'm wondering, that comment could have been from one of those. I also wonder if it could have been, late in the day, we're getting to 4:15. I need to get, because the recorder is there, they're on the bench. They've got, I can stop the hearing and leave. But they've got things they have to do, plus they have to go downstairs, they have to do other things. They may have a daycare that closes at 4:30, they kind of get to. So I don't know what that comment was with regard to rushing, but whoever that attorney was, if you look at the transcript of this, please know I apologize for that. And I usually am pretty good about if attorneys say, we really need more time, Judge. I'll say, okay, well, how much time do you need? And when can we set it? I also tell attorneys, when we're scheduling things, how much time do you need? They might say an hour. I'll say, are you sure? Because I'd rather have it set for too much time than too little time. Because if it's set for too much time for them to put their evidence in, that actually might give me time to step off the bench and do an oral decision rather than a written decision, which would speed up the process and stop the bottleneck. That's one of those things. So that's that comment I wanted to mention. And again, I hope it's an outlier, but I'm glad the person made it and I will be more attentive to that. The other comment that was made was a comment, and this was clearly not someone who had it in for me because there was a whole paragraph of these wonderful things. And then this person said, I think in hold without bail decisions, I don't think it's a bias, but I think he might lean more towards the state's position. And so, you know, every comment in the survey I think about, and because I've got that drive, that one I really was thinking long and hard about. I keep copies of my written decisions. So what I did, now I don't have the oral decisions that I've made from the bench, but I will tell you this. I try to use the same format for every hold without bail decision that I make. Do the same analysis, the same format. When I do that, that's my attempt to sort of take that unconscious bias that you hear about and set it aside as best I can, because I'm following the same format. I'm looking at the same factors. I'm trying to make sure I'm analyzing it the same way. So I don't know with regard to oral decisions, but if you want, I can give you, I made copies. You tell me if you want this. The Supreme Court actually reviewed an oral decision I made on a hold without bail case recently, and it was an oral decision. And if you want, I'll be more than happy to make sure you all get copies of that. And that will give you insight to my thinking. Okay. Thank you. So there's that decision for you. Yeah, that will give you their insight on it. Now I went back through and looked at my written decisions, and here's what I found when I did that. So there are two kinds of hold without bail cases. There are 13 BSA 7553A case, 13 BSA 7553 cases. Those are life imprisonment cases. And then there are the 553A cases. Those are felonies, an element of which involves an act of violence cases. In the hold without life imprisonment cases, there our presumption in the Vermont Constitution is flipped. Okay. In those cases, the presumption is hold, not release. In the 553A cases, that's those felony act of violence cases, the state has the burden in those cases to prove the evidence of guilt is great, and by clear and convincing evidence, the person's release poses a substantial threat of physical violence to the public, which can be just imposed. And also the state has to prove by clear and convincing evidence that there is no condition or conditions of release that can protect the public. So I went back through and I looked at my 553 cases and my 553 cases. What I found was this. In the 7553 cases, the hold without life imprisonment cases, there were 8 counts that were life imprisonment counts. 7 of them I did hold people without bail, continued to hold them without bail. One of them I found the state had not proved the evidence of guilt was great. The 13 BSA 7553A cases, the felony act of violence cases, there were 13 of those cases. 4 of them I continued the hold without bail for the 60 days. 9 of them I released the person on either conditions or bail and conditions. So I went and I did look at those. Again, I can't look at the oral decisions, but I will say from this, what I take from that review is that I do the best in my human judgment that I can do to hear the facts, to apply the Constitution, the statutes and the cases, and then make the decision being as faithful to the law as I can. I do realize now that I've done that analysis that I hold the person with the burden of proof, whether it's the state or the defense, to that burden of proof. And that's one thing that became very clear to me. At the same time, I recognize that perception matters. And so for that person, I need to do a better job of explaining why I'm coming to the conclusion that I'm coming to. And again, I don't know who that person is. I don't know what the nature of those cases were. But I do need to do a better job of that. And I will watch to make sure that I do not have an implicit bias toward either the state's position or a defense position. I think that's so important. But I do want to make sure people feel heard. Courtrooms are dynamic places, and I really try to prepare every day. For every case, I promised myself when I took the job, I would touch every file and look at it before I started. And I still do that to this day. I make sure I look at every file. Some I have more time to look at longer than others, but I do try to do that. But I realize that there are a few things that I can control. One of those, and for me, the most important of those, is my attitude. I try to have an appropriate attitude every day. I try to be prepared. I try to treat the litigants, the attorneys, the staff, as I said earlier, with the respect that I would hope that they would treat me with. And then I try to make a decision that complies with the law. Then the next day, I try to do it all again. But I do realize that despite all those efforts, there are times when I fail at that. But I believe it's how we respond to that counts. And that's why I, much like Judge Vera, continue to be better at this job every day that I do it, because I think Vermonters deserve that when I say that they deserve high quality justice. So I appreciate your time, and I am ready to answer your questions.
Thank you so much. Why don't we switch it up and begin with?
All right, thank you, Madam Chair. So I also have a few questions. So I asked the wrong judge the question about the continuing education junkie. It's you. And you're the one who just got
I got
years ago, got your
I
master's.
got the master's. Yeah, the master's in judicial studies.
And there was actually one comment that sometimes you're so involved in continuing education that it takes up a little too much court time. So
Yep.
I'm wondering if you could talk to that because.
Sure, I think I know where that comes from. Because I don't think that's actually those. I don't think it's actually the fact that I go to those. I think that comes from the fact that, and I think, especially from the fact that, all of you know that over the last few years, we have had a lot of new judges. So my one assignment for committees, some judges are on multiple committees, I have one. I'm the chair of the Judicial Education Committee. And in that role, Judge Zone asked me to teach our new judges starting in 22 certain things, bench skills, decision-making, the RFA docket, night calls, because I've taken a lot of night calls in my time. And so when we had all those new judges, they have to get trained within that orientation period. So there were times we did have to move some days.
Okay.
Yeah.
That makes sense. Well, good for you for all the continuing education. It's always great to continue learning. I have, this is a little, I'm just gonna ask you, who's our Secretary of State?
Who's our Secretary of State?
Yes.
Our Secretary of State is, I'm having a mind.
Because you addressed it to the wrong Secretary of
Oh,
State.
did I?
And to Secretary Condos, it's Secretary Sarah Copeland Hans in Kansas.
Yes, sorry.
That's okay. I also noted that, you remember me from the last time.
I do, you read me out.
Pardon me?
You read me out.
I did read you out, yes. And you used the 2022 questionnaire also. So,
I did?
yeah, so I would just
Oh, I apologize.
Yeah.
I thought I
want to
used,
make sure that you're checking your work.
I am sorry about that. That's I'm sorry.
It's probably the same questionnaire, but it's dated 2022.
Okay.
I was curious, first of all, really quick question, a summary judgment. I want to make sure I understand what that is, because a lot of your.
I submitted a summary judgment motion.
Is that when there's no disputed evidence?
They're correct. There was no disputed evidence that would lead to that conclusion, and that's why I submitted that decision.
Okay. Just want to make sure I understand it.
Yep, all those facts that I listed in that
Yep.
decision, those facts were all
Nobody said,
agreed
no,
to.
that's not what I.
They were all agreed
Okay.
to, so I can make a decision. based
And then
on
I was interested, and I think you demonstrated it in the writing samples, your formatted decision-making process, and you mentioned it too as a way that something you use to prevent bias, and I'm wondering if you could speak a little
Sure.
tiny bit to that.
And so all my decisions, and somebody actually said in one of the comments, he uses I a lot, and that may happen because of this. One of the things that I tell litigants is, especially self-represented folks, is that when you're before me, or when we get to the end, I say, okay, I've got to take this under advisement, which means I'm going to write a decision. When I write the decision, I follow the same format. I do it this way so that I'm trying to make sure that I'm fair. I will list, this is why we were here. That's sort of my opening paragraph. Then I say, here are the facts. And then I say, here's the standard and here are the facts. And I say, here's the analysis. And I say, that's the statutes or the cases. I usually say something like the people in Montpelier make, or the Vermont Supreme Court makes. And then I apply the facts to that law and say, there's the conclusion.
Mhm.
And then I have the order. The order is really important at the bottom because that tells our court staff what they have to do.
Yeah.
But that's my analysis. So for every decision I have, this is a criminal case that is at the pretrial stage. The state has asked the defendant be held without bail pursuant to 13 BSA 7553A. The defense has agreed that the evidence of guilt is great, but contests that there are no conditions of release that may be that would protect the public. I can tell you that's an opening paragraph.
Mhm.
And the beautiful thing for me about that is when I start, I do that for family court, that's sort of my opening. With all we do in the course of the day, if I know I've got an hour and I crank that opening paragraph out, my head is in this game and it's in that case. And then I just follow that.
Yeah, that sounds like a great method to not only be unbiased, but also to be efficient.
That's what I try to do.
Yeah. Thank you.
You're welcome.
Hi. Well, I guess, one of the comments that stood out to me, kind of just based on current climate, is that you are too lenient and give too many chances to repeat offenders. So I guess I was hoping you would address that.
Trying to figure that out. That might be from some of the situations where we're asked to put bail on people who might have a substance abuse issue. So what I have been doing more recently is when I have somebody who has a substance abuse issue, the state wants me to put $500 bail on them. But it's not, they're not showing up in court, which yes, affects how we can move the case along. But they've got a substance abuse issue. One of the things I learned from treatment court is people don't remember their next court date when it's 3 months out. And we may not give it to them that day. So what I've started to do is rather than say, I'm going to give you one more chance, I say, I'm going to give you condition 3 in criminal court, which is you're going to show up in court. It's a condition of your release. And I'll look at our schedule and say, your attorney is going to be here next Monday. So you're going to be here next Monday. And I have not looked to see what the statistics are on it. And yes, some people still don't show up when it's the next week. And then, by the way, the next time there is bail put on them. But if they show up, and that's happening, I think 50% or more of the time. We had somebody a couple of weeks ago who I didn't know if they would come, but a week. And I had said to them, you're going to be here on Monday at 1:30. And they showed up Monday at 1:30. And I looked at them and I said, thank you for being here. And they said, you're welcome, Judge. I knew that's something in treatment court. You have those people come every other week because they're not going to remember something that's 3 months out or 2 months out. And in several of those cases, when they've shown up the next week and it's not a crazy arraignment morning, we've resolved their case, moved their cases along. And again, I will tell you this, I don't think of myself as lenient or not lenient. I don't think of myself as courageous or not courageous. I think of myself as, here's what the law requires, and I just do my best to do it. But I did see that in there, and I certainly will keep that in mind. I think that was a staff comment actually, which surprised me.
Yeah.
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 Okay.
Thank you.
Evening, so I didn't see any negative, you know, I read through all the comments and pretty sterling, both from the attorneys and the staff. But I want to ask you a question about, because you actually touched the lives of a neighbor of mine because of your treatment court. I think people really respect you because you're fair and they come back because they believe you're part of their help remedy. So what's your feelings about treatment court?
I strongly believe, I knew nothing about treatment court before I got assigned there, other than Judge McCaffrey had started it. And I knew Judge McCaffrey as a little kid because I played basketball with one of his sons. I didn't play basketball with his older son because anytime we played, he would just dunk on us because he was. But that's what I knew when I went in. And that's the other thing, by the way, that may have addressed some of that time, is when I went to treatment court, I didn't know anything. So I had to go to trainings for it. And that did take me away from regular court hours. Treatment court holds people accountable. It does it quickly, but it also praises their advances, which is a big deal for these people. To have somebody in authority say something positive to them about their life. And again, I didn't realize this. You would know this probably. Right? I'm John Bland, I'm a kid from Rutland. That's how I look. I still, at 60 years old, consider myself a kid in Rutland. And these people look at me and I'm wearing this black robe and it carries this power. And when you give someone positive feedback in that circumstance, and this happens, by the way, not only in treatment court, it happens in juvenile court too. And somebody had asked a question about juvenile court before. You're getting positive feedback quickly, right? You're also holding people accountable quickly. I mean, talk about lenient. I think I probably sent more of our participants for an overnight at Marble Valley than they were used to. But I never did it first. That's never the first option in treatment court. Everything's gradual in treatment court. And you're really looking to get someone through our process, have them graduate, which is usually about 18 months. And the other thing too, I could take your whole night on treatment court. The other thing that's really interesting, and I know that the police department was excited about this, and I think the state's attorney's office too. When people are in treatment court, right, they've already pled. They've got two options. You get through it and you do well and you get a good outcome. You don't pass, you don't graduate. You get essentially what you would get if you were found guilty by a jury in many instances. So great benefit to you if you pass, if you graduate, and you go to prison if you don't graduate. Here's the key: when you graduate, all the statistics show this is an evidence-based court. You are less likely to commit recidivism than if you go to jail. It's also from the statistics I have seen, and I tried to figure it out with the Vermont statistics, but I haven't looked at it lately. But when I did look at it, it's less expensive to put somebody through treatment court for a better result than it is to incarcerate them. And I've been a taxpayer in Vermont my whole life, and so I like the sound of that with what we do. But I can talk to you, Senator, about treatment court for a long
You're
time.
very humble, but I want you to know you touch lives.
Thank you. Thank you. I appreciate that. And Judge McCaffrey was a master at it.
Thank you.
Senator.
Hello, thank you for being here. I don't have a question because Senator Collmore is going to ask what I was going to ask, but I do have a comment, which is reading through the comments was fascinating. We often get very similar comments over and over again, and then a few outliers, but these comments were so, and you use the word dynamic, there were so many different adjectives and even nouns in here, like workhorse and awesome and kind. And so it was a joy to read. And what came out off the page for me is that you seem to care about people and that you seem to love what you do. And so that is my comment, and thank you.
Thank you very much for that.
So I'm a big fan of treatment court,
I know you are.
and I've been to a couple graduations, and it's an amazing program, really is. You feel like the whole community behind you. And that is the other side of the coin. Two of the criticisms were that you spent too much time doing that and not enough doing other judges kind of things. So
Sure.
how would you respond to that?
So I went to treatment court for the one day every 2 weeks that I had. I did have to have that training, and that's what I'm wondering if that was.
Okay.
Because I think that those people or person who made that comment still indicated that I should be retained. So that's what I was thinking. But I did think about that comment, especially in that vein. And so it got me to think about the role of a judge and the role of a judge in the quote unquote everyday business of the court, I think might have been the exact phrase. I think treating people with respect is part of the role of the judge. I think being educated and continuing your training and caring about people is the role of the judge. I think that not treating our Vermonters and out-of-staters who come before us like they're on a conveyor belt when they come before the judge is part of the everyday work of the judge. And I think taking the calls in the middle of the night is the role of the judge. And I can tell you, I've done that sitting at dinner in a restaurant, to my wife's sometimes chagrin, but support, left the table and gone and taken calls. We do not take, our most recent vacations have not had cell service, because if my phone rings and I am on vacation, I will take that call. I will take phone calls in the middle of the night from RFA workers who are in other counties who, for one reason or another, have a judge who had an emergency or something and they know they can call me. I spent the one day a week in treatment court, and then I did that additional training.
Okay.
That's what I did.
Thanks, Ron.
You're welcome.
So I have a question. I do want to just give everyone a time check. I know we're scheduled to adjourn at 6:15, so
Oh.
clearly that's not going to happen.
Somebody says verbose.
I want to, if you have any time constraint, other end, okay. So I'll ask for, someday I'd love to sit down and talk with you about my question, but maybe if you have some brief thoughts on, I was fascinated to read in your letter of intent here that you mentioned the Bennington Juvenile Division and incentives to improve juveniles' motivation to engage in desired behaviors. And you mentioned ice cream and movie theater gift cards.
Yeah.
And it's like, is it that easy? I'm so curious because we hear from folks, our committee has heard that, oh, you know, juvenile delinquency isn't working, youthful offender isn't working because there's a certain group of older teenagers who are oppositionally defiant, which is a very frustrating term for me to hear because I think there's so much more to it. And I'm saying, how are you trying to reach them? And there's no data that we can look at on that. And so I'm just looking at this like, I don't know, is this some data? Are we talking about movie theater gift cards? Like,
So.
can you say a little bit about that program?
So I'll try to be brief, and I'm more than happy to chat in the meantime. I had started with not delinquencies, but truancies. I had kids who were coming before me who were going to school. And, you know, I hear one thing from parents, one thing from the school. First thing we did was got them all in the same room to talk, which was great. But then I realized, because I had been hearing all about brain development, and right, we want to get the brain to say, oh, this is a good activity to be involved in. So that's how that started. Kids would go to school, or, you know, not perfect attendance, but make some efforts. And so I found a donor, thank you to my spouse, my wife, who said, go for it. And so $5 ice cream cards and movie theater gift certificates at the Bennington movie theater. And when kids made improvement, and I didn't make, by the way, this gets back to my original comment, it's not me. I didn't make this, I sort of had the idea, but I got buy-in from the state's attorney's office, from the defense attorneys in the room, from my staff in the juvenile division down there. And so if someone had made progress, we reward them. And it wasn't just me going, this person's made progress, they get to be rewarded. Like, I would have attorneys in the middle of the hearing go, Judge, I think this is ice cream cone worthy. And so that's what we did. And then from there, I started using it in certain delinquency cases and other cases. I don't know if it's gonna solve any, defiance issues.
It's one data point though, and I appreciate that it's, you know, looking for creative solutions.
Two of them stole my question,
Okay.
but I can expand upon it a little bit.
Okay.
I had concerns about, the court docket running quickly enough these
Yeah.
days. I know, you know, COVID sort of took the blanket and disrupted everything, and it's been hard getting going again. Although it seems to be doing pretty well now. We have drug court, which is great, and I have noticed in my court that it takes a lot of time to run through that, and the rest of the court seems to stop. But now that we have a dedicated person, that's awesome. But the accountability court brings up another question to me, and it seems to be moving a lot of people through, the folks with, you know, multiple dockets that are sitting there. But your thoughts on that? Are we short staff judges at this point? Institutional knowledge? What is it that we're having trouble, you know, maybe getting right back to the same speed we were once?
You were before? Yeah. So I think there are lots of things, right, that can affect it. I was looking recently at Bennington, where I am with my cons, about, you know, those cases with 5 or more dockets. And how, you know, what's our status with them? They all have, in Bennington, they all have a next step, that can happen next. What I saw was a couple of things pop up, which actually may get to one of your, if you ask me the same question you'd ask before. People have violations of probation, and sometimes that active violation of probation is because of a criminal matter that's pending. So, right, so now you've got Bacon's issues, so you gotta figure out how to deal with that in order to move that case along. So that's one thing I saw. The other one, and I noticed this really, I should have noticed this before. I noticed this for the first time in the UK. So we have a lot of people who are on arrest warrant status who fall into those, you know, those buckets. And, you know, if we get them in, we can then take this next step, but I noticed that too. I do want to again, say that we were very fortunate in Bennington County during COVID. I was the presiding criminal judge there. Our state's attorney's office, our public defenders and our private attorneys continued to move files through plea bargaining during that time. And while we did have a delay, as everybody did, I saw them working very hard to move cases during that period of time. And the judge, bless you, as the judge there, I really appreciated it. And I just wanted to say that on the record today.
I will agree with you. There are an awful lot of arrest warrants out there, more than I've ever seen in
Right.
many years.
Not a question thieves, so I'll go a different direction here.
Okay.
The comments really, like a pattern is, I think, is a compassionate person, and I love hearing you testify because I can hear that in you, when you're driving, you think about the families outside the courts, and it's like, that's the best quality you could have in a judge. So, I also worry though, like, it seems like you take the work home with you a lot, both mentally and you answer the phone, right? So I'm wondering, like, if you could just talk about how you deal with, and like working with kids' issues and everything, it's like an emotional toll, right?
Yeah.
So how do you deal with that emotional toll? And maybe if you could like touch on some unmet needs you're seeing that brings people to you, that's helpful for us.
Sure. So I very much appreciate that question. It is one that I have been thinking a lot about myself lately. And it does, the work that we do, either of those judges will tell you, or any of the judges, you see stuff every day, much like our police officers, much like our other first responders, that can take a toll. I have said when I have been training judges in temperament and demeanor, I did not realize before I took this job, there's pretty much a bad word that begins with every letter of the alphabet. And I was shocked to see how often people throw those words around. In the juvenile division, talking about what Judge Barrow was talking about. That's a tough place. I say it is the most heartbreaking and most heartwarming court we have. Because it's much like Truman Court. You get wins, you see families reunited, which is awesome. And that's the goal of our system. But you also have to make some really tough decisions sometimes and terminate parental rights. And that does take a toll. I have been trying to exercise a little bit more. I've dropped a little bit of weight in the last year or so, which I'm going to continue to try to do. But it's tough. So my New Year's resolution was, I'm going to exercise when I want to exercise. Kind of weird, right? Here's why I did that. Exactly what you said. What would happen would be, I'd say, okay, I'm going to exercise. And I'd be like, you know what? I've got 8 cases under advisement. Let me just knock one on. Let me stay an extra half hour down here in Bennington. Let me stay an extra hour. I just want to finish this one thing or get this done. And so what I decided to do this year was, you know what? I'm going to take my 2 black labs for a walk. I'm not going to make up some work excuse or say that this is more important to me, but it is important. And we all know that. But getting those decisions out is important. Treating people with respect is important. Giving them enough time during the course of a hearing, which can slow us down, is important. But if there's something, they need to leave our hearings with an understanding that the person who's about to make that, now my back's to you, the person that's making that decision is heard them, right? That they've had that opportunity. Because that's what procedural fairness is all about. Right? A study from years ago, Lyndon Tyler, this study that talks about if they believe they've been heard, if they believe they've been given this procedural fairness to tell their story, they're more likely to comply with the order that the court issues. And if they'll comply with the order, we don't have to worry about them later. So that's helpful.
Thanks.
Thank you. You good?
I think so.
Thank you.
All right. Thank you all very much.
Thank
I really
you, Your
appreciate
Honor.
it.
All righty. The seat is nice and warm. Step on up. Well, thank you for being here.
Thank you. So I'm Judge Tom Walsh, and I appreciate your consideration of my request to be retained. Being a Superior Court trial judge is a privilege, and I try to remind myself that all the time. With that privilege comes great responsibility, and I look at the retention process as a little of both. It's a privilege to get feedback. As a judge, we don't get a lot of feedback in our everyday work, so it's a great opportunity for that. But it also creates a responsibility because I feel as though with that feedback, I need to make myself a better judge. This is my third time going through retention. I just started my 15th year. For all 15 years, I've been assigned to the Environmental Division. So I'm going to spend a few minutes to tell you about the Environmental Division docket because it's different than what you've heard from my colleagues tonight. I'm also kind of a unique person in the legal world. I was an environmental engineer. I practiced engineering for 4 years. I went to Vermont Law School. I did the joint degree, got the JD and Masters of Environmental Law and Policy. I practiced law for 18 years doing environmental land use litigation, 12 years in private practice. For 6 years, I represented the former Environmental Board. Because of that background, and when an opportunity opened up to be a judge within the Environmental Division, it was a natural fit, and I'm there. My colleagues would probably admit that if an opportunity came up to do something in the Environmental Division, they would probably decline. It's kind of like learning a foreign language. The process is somewhat similar. The application of law is similar, but the substance legal is very different and very unique. So what does a judge look at every day in the Environmental Division? We hear appeals from municipalities. So anytime somebody goes to one of our 260 municipalities to get approval to build a garage or build a factory or commercial space, that can be challenged to the Environmental Division. Act 250 permits from the 9 district commissions across the state, so larger projects generally, that's appealed to the Environmental Division. The 44 or so A&R programs, so wastewater water supply, deep well injection, underground storage tank, any of those permitting processes come to the Environmental Division. All of those matters, those 3 big topic areas, come to the Environmental Division. So we're an appellate court, but we do a new trial called de novo. So it might not be a full-blown trial and everything happened below, but when the parties define what they want us to review, we have a brand new trial on that limited topic. There are a subset of municipalities that have elected to go on the record. What's that mean? Well, that's a review kind of like the state Supreme Court. There's a record created at the municipality. We don't have a new trial when it's appealed to us. We get legal briefs, we look at the record that the municipality created, and we see to make sure that there's evidence in support of their findings. And then we look at their conclusions of law de novo, fresh. Now, in addition to all that, we have one other thing we do. That's all the enforcement work. So all of these municipalities, if somebody's not complying with the prior permit, or if they're not complying with the bylaws, they can initiate an action within the Environmental Division, and we have a trial on that enforcement. Similarly, Act 250 can do the same, as well as A&R. So it's kind of a unique experience within Vermont. Massachusetts has kind of a similar court. They call it the land court. Hawaii has a similar court. Nobody else does. All of these matters in other states go to the civil division. So we have a bit of a split of jurisdiction. Property rights, you might think, well, isn't that the Environmental Division? No, private property rights for the most part go to the Civil Division. It's the permitting and use and construction that comes to the Environmental Division. All of my matters are tried to the bench. It's a bench trial. We don't have jury trials. That means that every matter that I hear, I have to decide myself. I don't get the assistance of a jury. And for the most part, there's so much evidence that comes in either through motion practice, but especially at trial, I can't rule from the bench. I mean, I'll get stacks of paper that I can't review during trial. So once the evidence is in, I take it under advisement and I write a written decision. A lot of work in the written decisions, but it's part of the job. The gist of the dispute that commonly happens before the environmental division is private property disputes. A neighbor that doesn't like what their neighbor is doing. Maybe it's a big development and the neighborhood doesn't like it. And because it has to do with property rights, it's highly emotional. I've heard people say, you know, it's kind of like family law for the environmental field. It's really highly emotional. And when we make a decision, those neighbors have to live with each other after that. They don't get divorced and go to separate states. So we have to be aware of that, and it's not something to take lightly. I was very happy to see both attorneys and staff giving fairly favorable reviews. I did note that a few attorneys gave me low marks on judicial temperament, and I've taken that seriously and I've tried to think about it. So where did that come from? Well, I'll be honest. I'm not a chatty person. I'm direct. And we have a lot of time pressure throughout the judiciary, but within the environmental division especially. For my 15 years serving as a judge within the environmental division, the legislature is always looking at land use planning, land use permitting, and especially the appeals process. And I don't want to say we're under the microscope, but I get feedback a lot. You know, people are concerned about time and money. So I need to keep things moving. But as a judge, I'm committed to full and fair hearings. So I have to balance making sure everybody has their full opportunity to put in their evidence, but also keep the matter moving. And it's a balance that, you know, I'm human, I don't always get it right. On any given day, maybe it's a status conference motion hearing day. I might have 12 matters. They're stacked. They're each set for a half hour. So in that half hour, there might be many parties. I got to get through that matter to move on to the next one. Otherwise, the whole day is delayed. So I might have to press them a little bit. And I'm going to take this opportunity that I'm hearing a few comments about judicial temperament to heart. When I practiced with the former environmental board, I was fortunate enough to hear then Howard Dean speak. And his message in that speech was, how you deliver a message or a decision is as important as the decision itself. And I think that's speaking to me in this review, that if I'm going to make a decision and it has to be quick and on the record, I need to slow down just a second. I always try to make sure that people recognize that I've heard them and that I'm trying to make a fair decision. But maybe I need to pay attention to that a little more, because maybe that's coming through in temperament. Also, what happened to me this last 6 years, I served and I had 50% of the environmental division docket. There's one other judge in the state that shares the other 50%. During this past 6 years, my colleague unfortunately had a very significant adverse health diagnosis. And for about a year, I took on a significant portion of his docket. And I think in reflection, that pressed me a little more, gave me a little less time, probably left me a little thin in patience, and that might be where some of that's bleeding through. Whatever the cause, I mean, I would kind of like to know some more details about those comments. Was it a single appearance? What was the cause that they had that experience, so I could know more? But regardless, I'm going to pay attention to that. I was also very happy that there's 7 written positive comments. At least they're generally positive. There is one comment that's not positive, and they're anonymous. I'm pretty sure I know the matter that arrives out of. So if you would like, I'm happy to spend a little time and tell you about that matter. I don't know for sure that it comes from it, but I'm pretty sure. I'm not going to identify anybody. I'm not going to get into the you know, individuals that were before the court, but I thought it might help you both understand some of the struggles that a judge in my position has. It might help you understand environmental practice generally. Maybe it sheds a little light on this comment. So I'm happy to do that if that makes sense.
Sure, yeah.
Please.
All right. It was a housing project in Chittenden County. It was an Act 250 permit. So the substance of the matter was no different than all the other Act 250 permits. There's 10 criteria, 30 to 40 sub-criteria. Not all of them are before the court. In the environmental division, You file your notice of appeal and you have 21 days to then file your statement of questions. The statement of questions serves like a complaint in a civil matter. It defines the topics that the parties want the court to review and the decisions to be made. 21 days. In this matter, it took 8 months. I ordered 3 times the appellants to refile their questions so that they were workable and spent time with them trying to understand it. In the end, I drafted them myself. The applicant's attorney was fairly patient, but I could see the frustration because it was taking so long. So right there, the beginning of that matter, it was a challenge. There were 30 pretrial motions. So the matter took close to 2 years for me to do it. Total from beginning to end. Should have taken about a year, maybe a little longer, because it was a fairly big matter with parties in it. But 30 motions is a lot. The parties involved were 3 homeowners associations, a neighborhood group against blasting, and a property owner who was also an attorney that represented themselves. The homeowners associations wanted non-attorneys to represent them. And the way that works in Vermont is those representatives have to file a motion asking for specific permission to be allowed to represent the group. I mean, they have to show that they have authority to represent the group, that they have education, that they have experience, and they're not going to be a detriment to the court process of the other parties. I allowed 2 of those in and not 1 or 2 others. So right there, as a judge, I know this is going to be a bit of a challenge because we have non-licensed attorneys that don't have a lot of experience, which makes it harder because I got to spend more time with them. Maybe they file something, I got to spend time and they have to refile it. So there were reasons that were complicating the time it took and kind of the overall tenor that was happening before the court. The environmental division is statewide. We do a far majority of our work using WebEx, soon to be Zoom. It's all remote. That's not at my pleasure. I love to be in the courtroom. That's at the party's pleasure. It's very efficient for them. They're all over the state. Many of the experts that come before the court are from other states. They don't have to travel, so it saves them time, it saves them expense. But as a judge, it's a little harder to control things when people are on the monitor. So the first couple of status conferences, the first couple of motion hearings were remote, didn't go well. So from that point forward, I pulled them into the courtroom and we did it from there. So in the end, 2 years later, I wrote a long decision. I approved the project. Again, it was housing. The appellants took it up to the Supreme Court and it was affirmed. In that process, maybe because I've done it a few years, maybe, I don't know why, I figured that I would be sitting here today talking about that case. And I'm pretty sure that's what we're doing. And it's okay. I mean, for me, it's a constant learning curve. I don't know if you want to talk about some of the specifics about what was said. I think I would, because the opening line of that comment, it's a small state. It says I have a reputation. It's a small state. I think I would probably hear it. I have a law clerk that used to be in private practice in Burlington. She never heard it. So it kind of is disappointing to me that I'm here without an opportunity to speak to the truth of the comments. But I trust the process and you know, it is what it is. An allegation or offer that I'm biased to developers. In every case, my job is to referee the evidence coming into the court, either through motion practice, motion for summary judgment, or a hearing, or a trial. I then use that evidence to make findings of fact, and based on the findings of fact, I apply the law, and there's a conclusion. But let's be understanding of the process in Vermont. Developers, they hire a whole professional team. They hire lawyers, they hire engineers, they hire environmental experts, and they spend a lot of time and money designing their project so it complies. Well, if they do that, what's it mean? They're probably going to get an approval. So if you look at cases and how many gain approval in the end, it's going to outweigh those that, you know, get denied. Is that a bias of me? No. Is it a bias of the process? I guess in some ways, but you can see why it might head that way. Schedules. I do have a bias for developer schedules. Why? It's their project. Usually they're spending a lot of money trying to get their project through the process. So if a developer says to me, we need more time, Judge, I'm gonna say, okay, let's try to be efficient, but if you're saying you need more time, I'm gonna pay attention to that. Let me hear from the other parties as to what timing might be. In this particular case, there were half a dozen motions for more time by the opponents. I usually gave them a little more time, but not everything that they asked for because the developer, was suffering through the process. So do I have a bias when it comes to timing for developers? I guess so, but I think it makes sense. And if you all have thoughts otherwise, I'm open to it. But that's where I am. I don't know that there was any, I think there's a couple other things that might not ring true. When it's related back to judicial temperament, I have a responsibility to keep control of the parties before the court. If somebody acts out, I'm gonna be quick to kind of make sure it stays civil, because if I don't, it escalates. So that could be seen as lashing out. I think I do it pretty professionally. The other thing that happens is people will start to repeat themselves. So if an attorney asks for relief on some topic, if I answer it, that's the law of the case at that point. They might bring it up again, and if they do, I think to myself, okay, that's important to them. So attorney so-and-so, you did raise that before and I've ruled on it, so let's move on. If they do it a third time, I become a little more strict. Okay, this is the third time. I've told you I've ruled on it. It's the law of the case. You have it preserved for appeal. I don't want you to go back to it again. So, the level of accommodation changes as I think it's appropriate. And at the end, would it be lashing out? No, but I'm sure at times when people push that far, it's stern. It's a request. Don't do that again, please. So that was that case. Certainly, if you have questions about that or other topics, I'm more than delighted to talk to you about it.
Right. Let's just go nuts and start in the middle.
First, I want to say thank you for your service. I think you've correctly listed, if your colleagues had a top 4 list of dockets, your particular area of jurisdiction would probably be number 5. Just guessing.
Yeah.
And it takes a very special person, I think, and it's obvious that you really like what you're doing. So, and I'd be surprised if none of the 8 of us picked the exact thing that you already talked about. The 7 positive comments, they're easy to read. The one that calls being walshed is the one that you just referenced, and you've answered that to my satisfaction. So,
well, as I understand this process, again, my 3rd time, I'm pretty sure last time I was in the room when the public hearing happened, but Jess advises me, and Jess, my law school classmate, so I have full faith in her that we're not here for the public comment. Maybe there'll be an opportunity.
Yeah. Okay. I'll move on. Which way do you want to go?
We'll go to Senator.
I just want to say, since this is your last person, you're our last judge tonight, thank you for being here. That I respect all of you very much, and I really appreciate the work you do. It's so hard. So thank you. No, the only thing that stood out to me, other than what Senator Collmore said, was that you were born in Westfield, Vermont.
Well, that's not born there. You shouldn't say I'm born there.
Live there.
Yeah, that's where I live.
I have to be honest, I had to look it up on the map. So, yeah, now I know, right? It must be on the foothills of the mountains.
Now there's about 35 feet of snow left here.
Yeah, no, I was just curious, living in rural part of the state, how it's helped you develop as a judge, or if it's helped you develop as a judge at all.
So for 20 years, I lived in Burlington. 3 years ago, I sold Burlington and moved out there.
Okay.
Little change.
Yeah, big change. Thank you.
Sure.
So I'll echo what my colleagues have said. I'm on the Natural Resources and Energy Committee, and I know just enough about environment to be dangerous. I really appreciate what you do,
I sit next to
what you must have for experience and knowledge,
Yes.
and for what you must go through. The only other thing I was going to ask you about being Walsh, but I think I figured that out. Thank you for what you do.
Thank you.
Yeah, I'm not sure if I have anything, different to add or to ask. I'm also on my town select board and I know that we've had we've had issues before you, so, and we've had, yeah.
You're not alone.
Yeah, I'm sure, yeah. So, yeah, I mean, just thank you for your service and.
Thank you. It's my pleasure.
My turn. Thank you. It's nice to see you, Judge
Good to
Walsh.
see you again.
What I really want to ask you about, I bet you're not going to be able to answer.
Well, we'll see.
So if you have to say no, I'll appreciate it. But first of all, you were born in Cobleskill.
Yeah.
Which I grew up in rural upstate New York and multiple times went to the Cobleskill Fair.
Oh, nice.
Yeah, so, yeah.
Just as a side note, I leave after this hearing to go because my mother turns 97 this fall.
She's still in Cobleskill?
She is. She's still independent, drives, so she's doing well.
Yes.
I got her genes.
That is awesome. To your mom, but, well, what so since we last saw each other, I am now on the Natural Resources Committee,
Mhm.
sit next to Senator Williams. And one of the big issues we're contemplating is about appeals and where they're best suited.
Yes.
The Land Use Review Board just came out with a report and a recommendation that most appeals go to them, rather than you.
Yep.
So this is my question is, how much can you comment on this, and do you have any thoughts about where they're best suited and if you can't say anything about that, what you think I should think about as I'm thinking about this issue?
Well, I will do my best to avoid policy suggestions or encouragement or that, because I don't think that's our job. I think 34 Sons is here to back me up on this, and I know Judge Zone is watching, but I spent 6 years representing the former Environmental Board. So in 2004, Governor Douglas ran on permit reform. And why was he trying to do permit reform? What was the reasons for it? And the philosophy was, at that time, we had the Environmental Board that heard appeals from district commissions. And once the Environmental Board decided to go to the Supreme Court, for all the municipalities and for A&R, those appeals went to the Environmental Division and then up to the Supreme Court. So if you had a project that needed those reviews, you were on divergent paths, and you might go through the process and got a permit that said you had to paint the barn red from the Act 250 Environmental Board and Supreme Court, and a permit from the municipalities, the Environmental Division, and the Supreme Court said you had to paint it blue. I'm being very simple there, but
Yeah.
you'd get approval, but it would have different conditions and you'd have to start it over again.
Okay.
So the idea was bring them together. That was one big concept. There were concerns of consistency within the Environmental Board practice. I don't, what's true or not, that could have been solvable. But the real aspect of it was to try to get it running together and where you could coordinate things. So before the Environmental Division, developers have a choice. If they have to do municipal work and Act 250 work, they can do it all at the same time and it can come together at the Environmental Division. It's called coordination. If they want to do it independently and do one first and then the other one, they can. I gave you a decision in my written materials because that is a case that's relevant to what your committee is
Yes,
looking
it
at.
is. It's referred to a lot.
That developer decided to do the two reviews, one after the other.
Yeah.
So they might have gotten through the whole process in half the time that they actually did because they did municipal first and then Act 250. But that's their choice.
Mhm.
And that goes along with deference bias to developers. In my world, that's their choice. It's their project. How do they want to go through the system? What do they think is meaningful to them? I think sometimes there's a potential red flag, so they want to do Act 250 first. If they get approval, then they'll go to the municipality or vice versa. But, we see some developers do them independently, a lot will do them at the same time. Coming back to your question, you're dealing with a very small percentage of cases. Act 250 in 2024, I think there were 10. The percentage rate was 2%. Of all of the Act 250 applications, 2% were approved. Municipality, it's something similar. We don't know the percentage because we don't know how many municipal applications there are. But I think on average, we get about 65 municipal appeals a year. So all of the work that your committee's looking at and related to the Land Use Review Board's report focuses on the appellate level and just how to handle appeals, but it's a very small percentage of the cases. It's also a very small percentage of the time. I'm not saying it doesn't have impact and why we shouldn't be looking at it and why our judges shouldn't pay attention to it, because it is significant to those in the process. Yell at me, Terry, but I think if you want to make a difference, there's things to look at beyond the appeals.
Okay.
There's other ways, whether it be taking things out of jurisdiction, doing permits by right. You know, I think there's a lot of potential there.
Okay.
And the policy decision that the legislatures will have to make is knowing the number of appeals, knowing what you're talking about with how much time is going to be saved. For environmental board, the goal was 6 months. You know, it's not drastically different than the environmental division, and we have performed, and there's proof there.
Okay. Still okay. And I really appreciated that you gave us that case, the Montpelier case to read, because that is, I mean, that's kind of a landmark case of recent days.
Yeah, and you know, that's another topic that was hot for the legislature. I think now there's been a reaction to it. So for all
We
of
made
you,
changes to that statute since the case, and I
yeah,
thank
had to do
you
with
for the
party
better.
tax. It had to do with party. You know, and I think this is okay for me to say this. In my both private practice and 15 years as a judge, the legislature has consistently opened up standing, so more and more people could be in the process. So maybe it's time to look at whether that makes sense or not and to pull it back some.
I think we did, or did we?
That one does maybe.
Pardon, what did you say?
No, I agree that is, I think that's an attempt in that direction, is to start
Yeah.
saying, is standing too broad? That's a policy decision.
Right, but I thought we changed this statute last session.
You did.
We did, okay,
Yeah,
but it's
you
still,
did.
okay,
Yeah.
okay, got it,
But there's still that broad topic of standing that you could be.
in general,
You could be
okay,
looking at. Yep,
all right, heard, thank you.
you're welcome.
I was on Montpelier City Council for that decision there.
Small world.
Unlike the senator, I don't even know enough about the environmental court to be dangerous, so don't worry, but it occurs to me, you know, like reading through all these, you're like playing a different sport than
Yeah.
everybody else in the binder, right? So I thought I'd just ask, like, what's like one misconception that legislators have about the environmental court and something we should keep in mind as we draft legislation?
Well, I think maybe I touched on it some.
You did a bit, yeah, actually.
You know, there's a concern of time and expense. The environmental division is one element of the time and expense that it takes in Vermont to get through the permitting process. So you have the time and expense before the body below, the municipality, Act 250, A&R. Then for a very small subset of all those matters, some of them come for an appeal before the environmental division. So it's I mean, saying minute, maybe people would disagree with me. It's small. And there's so much effort that focuses on that small number of cases. Is that a misconception? I don't know. Sometimes I wonder why there's so much focus on such a small number of cases.
Great, thanks.
You're welcome.
Greetings. I don't have any real big concerns about the survey. I guess when the judge and the jury, you're gonna make a few
Yeah.
friends. And the employees and everybody sound great. I guess my biggest concern is I hope that someday when you plan to retire, you're already training a replacement.
So my former colleague, Judge Durkin, retired, and Judge McLean is now with me. And he had 30 years of practice representing municipalities in the land use and permitting. So he's pretty well schooled and he's come up to speed very fast. He's been about a year and a half in. So I think Vermont's in a good place with him coming on while I'm continuing in the career, and who knows who's next.
Good to know.
Yeah.
Thank you very much for coming.
You're welcome.
Oh, I didn't mean to like set myself up to be last, but I guess I did. I was I just was sort of taken within yours, this is your letter, statement of support. I noticed this 4-step, I love systems and process. And you laid out a 4-step process here for keeping things moving in the court. I don't know if you meant to, but I numbered them each step and everything. So you mentioned that it's a continuing challenge to afford litigants a full and fair opportunity to be heard while keeping things moving. So, and then you mentioned what you do, encourage a practical and efficient pretrial schedule, prepare well in advance, anticipate legal and procedural issues, and complete the proceeding in a reasonable period of time. I'm wondering how that's working for you and if it's replicable.
So something I started when I was first honored to be on the bench was trying to get parties to talk to each other before they come to court. So the notice of appeal comes in, statement of questions comes in, other parties show up. You have 4, 6, sometimes 8 weeks there before the court really takes consideration and starts pushing it. And I've always, when I was in private practice, if there was a dispute, I would, on behalf of my client, would pick up the other side and say, hey, what's going on? What do you need? What don't you like? Can we get rid of this? It doesn't seem many people do that right now. And I've started again to go back to demanding kind of, and it comes into judicial temperament, but it seems a wasted opportunity to use less time if I require the litigants to talk to each other before I see them. So that's one thing that I'm trying to renew again. I tried it before. I thought maybe after a while they would just know, hey, if you're in front of Judge Walsh, you better talk before you get there. So I'm starting that again. Yeah.
Well, maybe, I mean, I don't mean to presume that this isn't the same 4-step process that most judges follow or something similar, but I was thinking maybe you could reframe being Walshed and, it could be like, here, take the negative, turn it to a positive, and it's all about like moving things through. So, it's a suggestion. We don't all get to be verbed.
It's a home run, you really lost it.
It's all about framing. I'm a big reframe fan.
My engineering background, I've always thought things methodically that way, so that's probably that.
Yeah, I am far from an engineer, but I am a mom. And I think that really help. This is how I think or try to. So I appreciated the symptoms. I have nothing further. Anyone?
All set.
Well, thank you so much for your
Thank
time.
you for your consideration.
And just to repeat what many of my colleagues have said, thank you all so much for doing this very challenging, time intensive and emotion intensive work.
Especially after.
Yeah.
Excellent.
Thank you.
Thank you. Thanks. So with that, well, I'll just share our next meeting dates. That we are all in here, back in this room, next Tuesday, February 10th, for our second group. We have the Honorable Benjamin Battles, Honorable Michael Harris, and the Honorable Rachel Malone will be speaking with us on Wednesday, the following day, the 11th. We have a public hearing scheduled for 7 p.m. and that is in room 267 in the pavilion.
Yep.
I was gonna check with the Sergeant at Arms, or maybe Lindsay knows, but somewhere I'd like to provide details if needed for folks on how to get into the building after hours. If there was there.
Just your ID, thanks.
No, but for the members of the public.
For the members of the
Oh.
public,
Security.
because I don't think there will be security there at that time. Okay, so we will look into that. And people are, of course, able to join via Zoom, but for folks who want to be in person, I want to make
Yeah.
sure we know what that process
What
is.
did we do in the past?
Good question.
Yeah, I
We
know
have had
we've
it
been,
there.
I know we've
Yeah.
been there. And it
I don't
was,
remember.
it was at night.
One of us can stand at the door,
Yeah.
I think so.
let people in.
The window.
True, yeah, so we can work on that. And then we have a couple of holds for follow-up meetings, but I think those are the two big ones, next Tuesday and Wednesday. So I think that's all we have for this evening. Is there a motion to
So
adjourn?
move.
Second.
Okay, all those in favor?
Aye.
Any opposed?